Welcome back to the Illinois State Bar Association show, Illinois Law. Our topic tonight is medical malpractice, and I'm Sam Kavathas. I'm your host, and my guests are the Honorable Judge Elizabeth Budzinski, Ron Kalish, and Karen Enright. And we were talking about the process of evaluating the case. Now the case is there, and we file a lawsuit, okay? Once the lawsuit is filed, can you give the viewers a synopsis, Judge, as to what happens from the time the lawsuit's filed up until the time maybe before the trial or settlement?
Yes. When a lawsuit is initially filed, the plaintiff files a complaint setting forth the allegations of negligence against the doctor, and attached to that is a 622 affidavit setting forth its meritorious claim. Typically, the case will then proceed to what we call discovery, and discovery can take anywhere from 3 to 5 years in a medical negligent case for various reasons.
So when the client's wondering, why is my case taking so long, is that just part of the natural process of these type of cases?
It is. Typically, there's a lot of documents involved. We talked about getting the client's records for the injury in question and the negligence of the doctor. However, if the plaintiff has extensive medical history, it could take months to subpoena all the other records that the defendants want to get in order to find out about the other conditions of the plaintiff. And they're entitled to all that information. Whether it's admissible at trial is a different story, but typically they'll want every single medical record of the plaintiff, which could take months to subpoena, obtain, and then after that we have written discovery, which is answering interrogatories and questions about the plaintiff's condition at question and medical history.
What is your role during this 3-year process as a judge? I guess in the motion section, right? There's different divisions. There's ones where there's assignment judges where they have the case from start to finish, and there's also cases that have a different judge to handle it up to trial, correct?
What I do is I make sure that the process is moving along and that the parties are working towards getting towards trial. Typically, the parties will appear before me anywhere from 60 to 90 days on a status to advise me what is going on in the case. Where are they? Are they done obtaining all the medical records? Once they're done with the medical records, they go into written discovery. Once all the parties have answered written discovery, you have the deposition process. And in these cases, depending on the number of defendants, you can have anywhere from 5 to 30 depositions. And so scheduling them, getting doctors to appear for depositions, it's a very timely process.
And once that's done and that discovery process is over, what's the next step?
Trial.
We'll get to that in just a minute. Now, from the lawyer's standpoint, during those 3-year times, what are you doing with the client? What are you doing in the case? I know the judge has touched on some of those things, but maybe you can expand upon it a little bit if there's anything additional.
We're keeping the client updated as to the different medical records that we're getting, because often, as the judge has touched on, we need to get a history of their medical records. They might have had a pre-existing condition that might have affected the condition that they're currently suffering from. They might have had additional surgeries. So we're bringing in all of the doctors that have seen this patient for various medical conditions. Most of the time they have to be related to the injury in question. Once we get the depositions of the doctors and the physicians that treated the patient and the patient's deposition, then we go forward and we hire experts. Experts are the ones that sign the affidavits. Experts are the ones that kind of outline the negligence for the jury.
Do you need experts in these type of cases?
Every medical malpractice case needs an expert, because you need to have an expert testify against a physician in order to have a meritorious claim.
And all the defendants need to hire experts as well in order to get the case to a jury, because if the defendants don't have their own experts, then in essence the plaintiff wins. And
a layperson can't testify. Like, I can't go in and say, I had surgery yesterday and I think that my physician committed malpractice, because I don't have a medical license. The judge gives us jury instructions, and the judge gives the jury instructions that sets forth the law. And in those instructions it says that the only way that you can determine whether or not there's malpractice is from what the experts have said.
Okay, so it's not just any individual doing that, right?
Right.
Strictly on the experts.
Correct.
Now, when you file a lawsuit in these types of cases, is there a limit or amount that you can file for? Is there, a certain amount that you can file for, a certain amount you can get in medical malpractice cases in Illinois?
Right now there are no caps. I think think that's what you're referring
Right,
to.
I am.
In medical malpractice cases, those were determined to be unconstitutional in the state of Illinois. So ultimately, it's the jury's decision to decide, after they've listened to the case and listened to the evidence, the extent and nature of the individual's harm and the medical expenses, both past and future, and the disability and those things.
These caps that have been filed, there's always been a lot of issues on both sides of what the effect of these caps do or don't have in maybe the number of doctors that are practicing, the number of lawsuits are filed, or doctors that will stay insurance rates or things like that. In your experience as the attorneys, have you seen anything, talking to doctors or people about it, that it's had an effect, that you hear in one way or the other? Anything
Through
particular?
the different bar associations, we have done a number of studies. And first of all, the caps mostly affected women that were not working and children, which is one of the reasons why they were found unconstitutional, because they negatively affected children and women. We have found through our research that that the caps the lack of caps are not driving physicians out of the state of Illinois. In fact, there are more physicians practicing now than there have been. We found that insurance rates increasingly go up, and that doesn't have to do anything with the amount of cases that are filed.
Yeah, I sort of echo that, and this is my own personal opinions, that the problem isn't sort of this claim of these frivolous lawsuits with these huge jury verdicts. Those are very few and far between. We talked earlier about how unless you have an expert that's going to testify for you, and unless you have a substantial enough injury, you can't even get the case filed. And so I really think that it's a combination of the economy and the insurance industry itself having problems with profits. I think there's they're not paying the doctors enough in their payouts, and I think that the filing of frivolous lawsuits is probably the smallest part, if at all, of the problem.
Judge, in your cases that you see a trial, usually the outcome, is there more one side or the other in malpractice cases? Is there a higher percentage for one side or the other that you see?
Well, surprisingly, I think there are more defense verdicts than there are plaintiff's verdicts. In looking at the last few years and kind of talking with my colleagues about the percentage of plaintiff's verdicts are in med-mal cases, I'd say about 42 to 48% are for the plaintiff and the rest are for the defendant. So it's very difficult to prevail.
In the last few minutes that we have of the show, I'd like to get into the actual, after you get to this discovery process, before you go to trial, is there anything you can do to try and resolve the case, or does the judge do anything or anybody do anything? Maybe briefly you can tell us about that, and then we'll get into a little bit about what happens at a trial.
Sure. Whenever a case comes to me and we're going to trial, I will ask the parties if they want to settle. I think to settle a case is the best alternative for everybody. Nobody's happy, but it's a compromise, but it's better than leaving it up to 12 unknown people as to the outcome of the case.
And as medical malpractice cases, I mean, because as you said, you don't know for sure. You never know if you're going to win or lose, and that's why maybe settlement is a good route to take. And a lot of the cases are settled before, or it depends on this area of practice.
It depends. There are many defendants who will not sit down to the table and negotiate a settlement. So in that situation, it's very difficult to bring the parties together. But if you can do that, I think that's the best alternative.
And that's one of the reasons why you want to make sure when you get a lawyer to begin with that it's a trial lawyer. It's a lawyer who can take the case from beginning to end, because when it comes time for settlement, that lawyer is going to be in the best position to recommend either you should settle the case or you should go to verdict. And you need someone who has had that experience.
And I would also say that, unless your lawyer is prepared to begin that trial, I don't think that you're going to really maximize the value of your case. And so going back to finding that lawyer, and that's why it's important, if the plaintiff's lawyer isn't ready and has his or her ducks in a row, I can tell you the defendant is not going to make an offer.
And when the case gets to trial, who was the case tried before?
Well, in Cook County, it's sort of a random assignment of a judge, and that judge is generally not familiar with the case at all. And we appear and we educate the judge about what our case is about, and and it goes from there.
And who?
And we pick a jury.
A jury. So it's before jury then. And how many
Right.
people? How many people are on the jury?
12.
And are these people, where do they come from, the jurors?
All over Cook County. So it's random. You don't know who's going to be called up into your courtroom where the case is being tried.
And
They-
these people have no knowledge of the case, nothing, they've never heard anything about the case before?
Nothing. And one of the most important instructions that I give them is that they can't discuss this case with anybody. They can't do any research. We're living in an age of technology, and they can't look up the doctors or the plaintiffs on the internet, Twitter, Facebook, or anything.
We just have a minute left in the show. Briefly, after the jury's picked, what happens with the trial? How long does the trial take in these medical malpractice cases?
Most of our trials take probably between 2 and 3 weeks, depending on the amount of physicians that we have involved. Sometimes they have to fly in from other states. We start with an opening statement. We have a number of exhibits. We try to blow up things for the jury so that they can understand the medicine, because sometimes this is the first time they're hearing about this type of case. We put on our evidence, the other side puts on their evidence, and there's a closing, and then the jury takes it to deliberations with a set of instructions that the judge gives them.
Well, you know, we're out of time. I know there's a lot more we could talk about with the medical malpractice cases. They sound very complicated, and it's important for individuals to get a good attorney to handle these types of cases. I'd like to thank my guests, the Honorable Judge Budzinski, Ron Kalish, and Karen Enright, for being with us here on Illinois Law, sponsored by the Illinois State Bar Association. And thank you and good night.